Hello everyone, and welcome to the third broadcast of a 5-part webinar series that is being put on by the ACS Chemistry and the Law Division. I'm Michael David, and I will be your host for today's broadcast, which is focusing on how to avoid pitfalls when conducting research with other groups. We will be joined today by MaryAnne Armstrong of Birch, Stewart, Kolasch, and Birch, and Krista Bianco from the firm Finnegan, Henderson, Faribault, Garrett, and Dunner. If you have any questions or comments, you can enter those using the questions panel. The slides for today's webinar can be downloaded from that same control panel, and the recording will be sent to you once it has been posted. And now, I'm pleased to turn time over to Krista to get today's presentation started.
Thanks, Mike. My name is Krista Bianco, and I am the current program chair for CHAL and also a past chair. In the first two webinars, we discussed some of the procedural and legal aspects of attaining a patent, as well as the different types of patentable inventions in drug development. In this third webinar, MaryAnne will discuss important issues that should be considered when you want to enter into a collaborative research agreement. MaryAnne is also a past chair of CHAL and has practiced in the intellectual property field since 1995. She has worked with both large and small companies and universities in the fields of pharmaceutical and organic chemistry, immunology, and biotechnology, among others. She has also advised clients on numerous collaborative research agreements. With that introduction, I will turn the webinar over to MaryAnne.
Thanks, Krista. Thanks, Mike, for hosting, and let's just jump into it. So as Krista mentioned, we've had some seminars and hope people were able to tune into those on patents generally, and so I'm not going to spend a lot of time on what intellectual property is, just one or two slides to give a real quick overview, and then jump into really things to think about in collaborative research and how to avoid some of the problems that can potentially arise. So the types of intellectual property that come up in collaborative research, patents, of course. First thing that everybody thinks of is patents. And why are they important? Two reasons. One, of course, to protect any innovations that might come out of the collaborative research. But there's another issue, too, that sometimes arises with patents, and that's that a third party's patent might be a block to the commercialization of any innovations that come out of the research. So as I'll mention later, one of the things that parties need to think about before entering into an agreement is what else is out in the field? Who else is out there and what are they doing? Trade secrets. Trade secrets are becoming more and more important as a form of intellectual property protection. And trade secrets are important because some technologies are just not suitable for protection by patents. For example, manufacturing and production technologies may not be really suitable for good, strong patent protection because it may be very difficult to prove infringement, and so a trade secret may be a better option in that case. Trade secrets also have the advantage that they can protect the technology in perpetuity, so essentially forever, unless an independent party develops the same technology. And then moving on, what about trademarks and copyrights? Copyrights, not as important in collaborative research, but trademarks do arise in collaborations, particularly if an innovation is being commercialized. Sometimes you have issues of shared branding and advertising, and the parties really need to come to an agreement about, are you going to let your partner use your branded technology if they're the ones launching the commercialization of the new innovation? So, but before any kind of research begins, what do you need to think about? Because you want to tell everybody how wonderful your technology is. But at the same time, you don't want to share everything with the world and let out proprietary information. So how do you go about doing that? So before the talks even begin, whether or not to enter any collaboration, there needs to be an NDA or non-disclosure agreement in place. The NDA will allow the parties to share their respective proprietary technology and expertise to determine whether or not a collaboration is something that's attractive, and without sharing it to the world and keeping that information protected. So step one, there has to be an NDA in place before any information is shared. The types of provisions that you should really consider in your NDA, I think this first one on the slide, this is something that everybody thinks about. Well, of course, you're not allowed to tell anybody what I tell you. That's what the NDA is for, right? But many times, especially companies may also want to have a prohibition in the NDA that prevents any kind of disclosure of the fact that you're even discussing a possible collaboration. Particularly, this may be important if a company is entering into a new field that maybe they traditionally have always been in cardiovascular research, and now they're thinking about going into oncology. But they don't want potential competitors to know that they're thinking about going into this additional field. They may have a provision in the NDA that says that the parties cannot even disclose to anybody that they're in discussions for a possible agreement. So as I mentioned earlier, what are other people doing out there? So you and this potential partner think you can come up with a great collaboration, but one of the important questions to ask is, has a freedom to operate analysis been done? What are third parties doing? Who are the competitors out there? And what kind of patents do they have? How tight is this field? So one of the questions that should be asked of a potential partner is whether or not they've done a freedom to operate analysis, and if they have, what are the results? What are the patents that have been identified? Have they come up with a basis to invalidate those patents or to design around them? Could the patents be licensed? And if the patents are licensed, who is going to assume the cost for any licensing obligations? This also, when you do the freedom to operate, then you have to consider, well, are the risks so high that you want to walk away from the collaboration? You don't want to be in the middle of the collaboration, having invested time and money, and then you realize that a third party actually has a patent that will create a significant block to commercially developing anything that comes out of the collaboration, and there's no opportunity perhaps to license or invalidate that blocking patent. And you want to know sooner rather than later whether or not you just want to walk away from it. So the next step, let's assume freedom to operate came back great and collaboration is going to go forward. Now the big thing is get the research agreement in place. And most of the disputes that I have seen over the years arise because of very quickly, very poorly drafted research agreements where the parties don't really think about what they want to put into the agreement, and they take a stock boilerplate template research agreement, they sign off on it because they just want to get into the collaboration, and then problems arise and the agreement falls apart and the relationship falls apart, and suddenly now there's all sorts of disputes because of a poorly drafted agreement. So this is kind of your prenup into going into things. This is the research agreement. So what kind of things do you want to put into it? Well, what is the scope of the collaboration? What are you going to jointly investigate? And this is important to actually discuss, as we'll see in a little while. You really need to decide, well, what's the project? What's the scope of the project? What are the boundaries on the research? Who's responsible for what aspect of the research? For example, who's going to contribute different resources, different manpower, lab space, instrumentation, coming up with different milestones? Which party has which responsibility in this research collaboration? And as I mentioned, are there bounds or limits on what can be permissibly done under the collaborative research? Can one party run off and keep pursuing something that they found interesting, or do they need to have agreement with the other party before they do that? One, and as I said, defining the research project up front is incredibly important. And you also need to bear in mind, research is inherently organic. Everybody involved in research knows that you do one aspect of the research, you look at one question, and the answer you get, the results you get, may lead to something else that you had never anticipated. So research is, as I said, it's organic, not just organic chemistry, it's organic as a buzzword. And as a result, the objective of the research, of the collaboration, may evolve over time, and that's okay. And it's always possible to modify the research agreement as the research changes. But let's look at a scenario. Say A and B, two different companies, company and university, two universities. They enter a research agreement to develop new compounds with an efficacy for treating disease X. And that's what the research agreement specifies. We are entering agreement. We are going to work together to come up with these compounds to treat disease X. However, during the course of the collaboration, Company B notes that a jointly developed compound shows promising activity to disease Y. What happens here? And depending on the drafting of the agreement, problems can arise with regard to treating disease Y. So, question, can one of the parties independently pursue the activity against disease Y? And I'm going to turn this over to Mike now to do a little poll for us.
All right, thank you. So we just want to ask all of you, can one of the parties independently pursue the activity against disease Y? Here is a little interactive window where you can just quickly click either yes or no, and just right on the screen there. And once you do that, I will gather those results. Reminder while you are entering those in that we are eager to get some questions for you, and the earlier you ask those questions, the more we have a chance to get to your particular question. So no need to wait until the end of the presentation before you start to get curious. And with that, I'm going to close this poll in 5, 4, 3, 2, 1. So MaryAnne, 56% of the audience said yes and 44% said no.
Okay, so we're split nearly even. That 50% of the people said that company B can go off and do whatever they want with disease Y with this jointly developed compound. And as a little bonus, just throwing it out there as a rhetorical question, but in the first scenario, it was jointly developed. But what if only B was responsible for this observation regarding disease Y, and maybe they were the one who came up with a compound, but they couldn't have made that observation unless they without using the proprietary knowledge contributed by A. So in this case, B made the compound by themselves, but they were still using A's knowledge. And would your answer have changed with that additional bit of knowledge? And what you will see as I go to the next slide is there's no answer. And the reason there's no answer is because there's no right or wrong to this. It all depends on what you put into the research agreement. If you put a boundary on it that says that an individual party may not go beyond the defined scope of the collaboration without the agreement of the other party, then B cannot independently run off and do their own thing with regard to disease Y. On the other hand, if the agreement is silent or the agreement specifies that they may, then by all means they may. So again, you need to think about how do you want this handled when you're drafting the research agreement. Do you want each party to be able to go off and do their own thing if they come up with some independent finding during the collaboration, or do you want a boundary on it? Again, no right or wrong answer, just depends on where you want the collaboration boundary to fall. One of the big things that should be addressed in collaborative agreements, which unfortunately is oftentimes given a very short sort of back-of-the-hand cursory attention, but not detailed attention, is the handling of trade secreted information. Oftentimes, research agreements have one very short clause that says that all proprietary information shall be handled with due and appropriate care, must be taken by the parties to protect any proprietary information received from the other party. All very nice. But what does that mean? What is due and appropriate care? What one party deems as due and appropriate, the other party may find woefully inadequate. And this was particularly the case if you're dealing with a large pharma company versus a small company or sometimes a university lab. Dealing with large pharmaceutical companies, you have to go typically through multiple layers of security to get inside the building even, and certainly all information is incredibly protected. Not the case in a university. Most universities, you walk in the front door, and if you need to go visit somebody, you go to their lab and you visit them. So the agreement really should define what steps should be taken to protect proprietary information. For example, physical security. Can there be access to lab space to outsiders, or must guests be escorted at all times? What about how should the materials be kept? Do they need to be kept in a secure locking facility if they're not being used? What about electronic copies? Do they need to be on a secure server? Can copies be made, whether it's a photocopy or an electronic copy? Can somebody put something on a USB stick, take it home, and work on it at home? If you're working at a pharma company, the answer to that would be no, you may not. You do need to keep it there. You cannot make copies. But at other companies, it may be very commonplace to be able to take things home and work on them. Do things need to be marked as being confidential? And again, what about transmission of information? Can it just be emailed back and forth, or does it need to be sent in a secure encrypted manner? Now, what I have on this particular slide, is just some examples. It's certainly not an exhaustive list, but it just highlights the types of physical security concerns that may need to be discussed regarding handling proprietary information. Similarly, what about access to the information? Who gets access to it? My recommendation is that the agreements say that any proprietary information may only be shared on a need-to-know basis. The simple reason being that the more people who have access to information, the more difficult it is to control the proprietary nature of that information. If people without a need to know are given access, it also becomes much more difficult to prove that the information was a trade secret. One of the requirements in showing that a trade secret is indeed trade secreted is showing that appropriate care was used in maintaining that information as a secret. And part of that is that you restricted who actually has access to that information. The agreement with that needs to define who is a need-to-know person. One of the big things that comes up in research today is the use of CROs. A lot of aspects of technology, for example, doing synthesis of new compounds, things like that, is outsourced to CROs. Is a CRO a need-to-know entity? And again, no right or wrong answer, but something that probably should be spelled out in the research agreement as to whether or not a CRO may be used and what kind of access are they given to the information. And again, what about now at the end of the research project? Standard is that any proprietary information should either be destroyed or returned. Generally, it's if I've given you something, you need to give it back to me, and any copies of it you need to destroy. And because unless it's something that's in the public domain. And similarly, I mentioned CROs. What are you going to do with CROs? Can they be used? Can they not be used? How do you vet them? things that really need to be discussed before the research starts and things that should be put into the research agreement. Now, this is one of the big areas, and that's procedures for making public announcements and publications. This may not seem like a big deal, but this ends up being a very, very important issue, particularly when you've got very, very different parties involved in the collaboration. Particularly if, for example, you have a large company and a university, or a small company and a university, or a small company and a large company, because the value that the respective parties place and the priority that they place on either publicizing or maintaining information as secret can be very, very divergent. Small companies are often very interested in bringing in more money. They need more venture capital money. They need to make, particularly if they just went public, they need to make their shareholders happy. How do they do that? By getting really good publicity. And so oftentimes a small company, and sometimes university labs as well, if they're looking for additional industrial money, they want to publicize good new findings. They want to publicize the innovations. They want to get out there, show the public all the great technology that's been developed. Larger companies typically like to play their cards pretty close, and they don't want things getting out in the public prematurely. They want to keep things in close until they know where the project is going. As a result, any collaborative agreement really needs to have very clear provisions as to how public announcements and publications can be made. And there needs to be clear provisions regarding the public dissemination of any information about the project, whether it's in a publication of a journal article, an oral publication, or very importantly, a press release. I have seen multiple patents invalidated over press releases because somebody went out and said how wonderful the technology was, and that press release was then later used as prior art to invalidate the patent. All public release of information regarding the project should be withheld until the appropriate patent has been filed. That's just without saying that. Don't discuss it until there's a patent on file. But even after the patent application has been filed, there needs to be a mutually approved release of information. That way, it avoids the inadvertent release of information which one party wanted to remain confidential or wanted to be withheld until a later time. And again, this needs to be put in the agreement. One of the other provisions should be, what about notice? That if one party wants to make some kind of public announcement, there needs to be a provision in the agreement that says how much notice do they need to give to the other party. For example, you cannot email the other party a day ahead of time and say, hey, we want to do a press release tomorrow. We want to tell everybody how great this is. That's not really sufficient notice for the other party to review and consider what's going to be publicly released. So there has to be some kind of notice provision in the agreement. Again, doesn't have to be specifically defined as to what the notice agreement is or what the notice provision is, how long it is, but it should be something that's workable. What about now ownership? One of the other big issues that come up. Now with patents, and this will be discussed some more in a later seminar under inventorship, but in the absence of any agreement to the contrary, each joint owner can basically do whatever they want. And unless there's an agreement in place, each inventor is considered to be 100% owner. So let's say we have 3 inventors on a patent, and they're all going to jointly own it because there's no agreement that says anything contrary to that. That means each inventor can go off and they could separately sell 100% of that invention. It's kind of a legal nuance to say 100%, but what that means is that the first inventor can go to Company A and license the entire patent to Company A, and Company A can now practice any aspect of that invention that they want to. Inventor 2 can go to Company B and do the same thing. Company A and Company B now are both operating in the same field and both can freely use that patented technology. So it becomes very, very important to have an ownership agreement in place as to how ownership of any technologies is going to arise. And this became very important in the case involving Stanford and Roche, where there was a dispute over the ownership of the patent. In this case, to give just a little bit of background, so the researcher who was an employee of Stanford, when he went to Stanford, he signed an employee agreement, and in the employee agreement he said, it says, I agree to assign or confirm in writing to Stanford and or sponsors that right, title, and interest, blah, 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 to such inventions. Well, as part of the research, there was a collaboration with CETUS. And so under the collaboration, he spent part of his time at CETUS. And to go onto the CETUS property and work in the CETUS lab, CETUS also required an agreement to be signed. And the CETUS agreement said, I will assign and do hereby assign to CETUS my right, title, and interest in each of these ideas, innovations, and improvements. So now this researcher has signed 2 different agreements regarding the rights to the invention with 2 different entities. And the question is, which one of these agreements is binding? So who owns the rights to this invention? And I'm going to turn this now over to Mike so we can do our second poll.
All right. So our second poll is simply, who has the rights to this invention? Is it CETUS or Stanford? And if you look on the screen, you'll see a little bit of the text about what was in each of the agreements. And here comes that interactive window. So again, was it CETUS or Stanford and or the sponsors? You can click directly on the screen to let us know. And votes are coming in pretty quickly, so I will be closing this poll in 5, 4, 3, 2, 1. And this was another kind of close one. It was 55% for CETUS and 49% for Stanford.
And that's really an interesting answer, that it was really so tight, because the answer is CETUS. That the court found that this language that was used in the Stanford agreement was a promise to assign, but that the researcher had not ever taken that second step of actually, in fact, assigning. He made a promise to do it, but he never did it. The language, on the other hand, that was in the CETUS agreement was an actual assignment of rights. So what ended up happening in this case was, so CETUS, as many people know, was acquired by Roche. And down the road, Stanford sued Roche for infringing the patents, which Stanford believed they own. Roche turned around and pulled out this agreement that had been signed by the researcher assigning all the rights to CETUS, which they then acquired when they purchased CETUS, and said, no, I'm sorry, you don't own the patent, Stanford. We do, because the rights were assigned to us. And the court agreed with Roche and declared that Roche was the owner of the patents, and Stanford lost. And instead of having a multi-million-dollar damage award, they lost their patents because of the wording in their employee agreements. So my recommendation is review your employee agreements, whether you're a company or a university. Review the language, see does it align more with the CETUS language or the Stanford language, and in either case, just to make it crystal clear that you are the owner of any technology, have the inventor sign an actual assignment document. It is critical to have assignments signed by the inventor, so that way there can be no dispute as to where the ownership of the technology lies. So now, next provision to consider. What about dealing with problems? Problems arise. In any relationship, there will be problems. Some of them are foreseen or maybe predicted. For example, disagreement over the interpretation of what the terms of the agreement mean. No matter how well drafted any agreement is, there will always be some disagreement as to what a particular term or particular provision, a particular obligation means. And so that's something that needs to be considered. What about breach of the agreement? It's not uncommon to have one party breach the agreement, whether deliberately or inadvertently. What if there is a change of entity of one party? Company may fail, or today it's not uncommon to have an M&A happen and the party you thought you were in a collaboration with has now become a different entity. There's different options for resolving conflicts. There's mediation, where a mediator will try to get the parties to work it out. There's arbitration, where a third party will actually adjudicate a decision. And then, of course, there's a civil action, but then you need to also think about provisions as to where will any civil action take place. Again, no right or wrong answer to any of these. Any mediation, arbitration, civil action, they're all correct answers, but there are things that need to be considered. You need to decide which option do you want to pursue and put that into the agreement. Cost. Cost is a biggie for any research agreement. And while people oftentimes think of the research costs, you also need to think about the patent-related costs. And this does not just include patent prosecution. This also includes, is there going to be a freedom to operate search done and some kind of analysis? And who is going to control these decisions? Who gets to say, let's spend the money, let's not spend the money? What about enforcement costs? While it costs a lot to get a patent, it costs even more to enforce the patent. So who is going to foot the bill for any litigation? I threw some figures up on the slide that if a litigation goes through all the way through final disposition, you're looking at close to $3 million. It's a lot of money. Who's going to pay for it? With 80% of the litigations, there are now invalidation proceedings before the patent office. Who's going to pay for that, and how is it going to be handled? Other provisions that you might want to consider: indemnification. Do you want an indemnification if you're using somebody else's technology? What about litigations? In the U.S., a lawsuit for patent infringement may only be brought by the owner of the patent. We mentioned ownership early on, that you need to decide how is the ownership going to fall out, who's going to own it. Oftentimes, collaborative agreements are structured such that one party may have ownership of the patents. For example, the collaborative agreement may say that if inventors solely at A develop the patent, A retains ownership with a license to B. If inventors at B solely develop it, B retains ownership with a license to A. If it's jointly developed, then the ownership will be shared. Well, the issue with shared ownership is that you need to, for a lawsuit, you have to have both owners involved. Similarly, if there is a license, maybe A is the owner, but license it to B. Let's say that A is a university and they give a field of use license to B to practice the patent. That means B, the company, can't sue an infringer unless A is also a party. Now the university is suddenly involved in the lawsuit, whether they like it or not. And you need to think about that when you're putting provisions in regarding litigations. There needs to be cooperation provisions and there needs to be cost provisions. You also need to think about the fact that as a patent owner, you may be required to participate in the litigation whether you really want to or not. Finally, What about termination of the relationship? Also referred to as the death and divorce clauses. Because relationships come to ends. Just like in life, collaborative agreements come to ends, and sometimes it's not a planned end. Sometimes it's because one of the party dies, or sometimes the parties need to get a divorce. So you have planned termination. So you define target milestones. We've achieved what we've set out to reach, and now we're just winding the project down, and now we'll follow the provisions that we have in the agreement for the return of any information and any future relationship in terms of cooperation with, for example, licensing or litigations, things like that. What about unplanned termination? There needs to be clauses in the agreement dealing with an unplanned termination. For example, termination for breach of the agreement. One party failed to meet the milestones that were set forth in the agreement. One party failed to provide required resources. What happens in such a breach? What can the parties do? What if one of the parties goes bankrupt? They die. They're not in existence anymore. What happens to the research? What happens to all the information? What, again, I mentioned earlier, what if there's a merger and acquisition? What happens if somebody gets acquired by somebody who is a competitor? What if Party A is a small company and they are in a research collaboration with Party B? Party B is a large company. What happens if Party A, this small startup, now suddenly gets acquired by a direct competitor of Party B? What happens to the collaboration? So the agreement needs to have provisions in there to decide what's going to happen if there is a merger and acquisition. Will that allow for termination of the agreement? And again, if that does happen, if there is an early termination, you might want to think about having a buyout option for the non-breaching party, that the non-breaching party has a right to, at some value, purchase all of the IP rights of the breaching party or the early terminating party. And then also upon termination, and this is with regard to either planned or unplanned termination, the agreement needs to define what happens with any shared proprietary background knowledge upon termination. Can a party continue to use the knowledge obtained from the other party? Is there an option for a license to continue to use it? From our scenario earlier on, can Party B continue to go work on research regarding treating disease Y, even though that wasn't part of the original agreement? Again, no right or wrong answer. It's really just going to depend on what the parties want to put in the agreement. And the take-home from a lot of this is that there really is no right or wrong. But the homework needs to be done ahead of time. You need to think about where are your priorities in the agreement, what's important to you, what's a deal breaker, what's something you're willing to give up, and based on that, those provisions need to be put into the collaborative research agreement. And that concludes my portion of the slides, and if anybody wants to reach out to me, if you have questions after we get off the webinar, feel free to reach out. My contact info is on this slide, and I'm going to turn it over now to Krista so that we can do some Q&A.
Thanks, MaryAnne. We had received a number of great questions. One of the first questions was, assuming one party has some background IP, how important is it to make the other party license the background IP before any collaborative work on further technology developments occurs? Or do you have any advice for handling background IP? What are your options?
Well, if the background IP is patents, then it can be in the agreement that any of the, particularly if the other party, if it's a large portfolio, you may not want to give them access to everything you have. So in that case, the agreement should specify that the other party is licensed to use certain technology, certain IP, and put the parameters on the use. So let's say, for example, Party A has a huge portfolio and they're in collaboration with Party B. The agreement should probably set out that which patents Party B is allowed to use and in what context. Maybe they don't want to give a full scope of license. Maybe they want to do a field of use license for those patents just for the collaboration, because the patents may be far broader than the scope of the collaboration. But again, this is something that needs to be set out in the agreement. There's no right or wrong answer. It's what is Party A willing to allow Party B to do with the IP. But it would help to have it set forth in the agreement what the scope of permitted use is.
Also, you mentioned revisiting contracts over time. Do you have any recommendations or best practices for when both parties should be reviewing and revising any collaborative research agreement?
Anytime there is something which I would call a material change in the scope of that would affect the scope of the agreement, it should be revisited. And by material change, I mean that the scope of the research has changed, so that the defined scope that was set forth in the original agreement is no longer really applicable to where the parties want to be going with the research. There was a material change in the identity of one of the parties. They had a merger, they had an acquisition, for example, they were a privately held company that's now public. Yeah, so they've changed their status. You might want to revisit that and see if that's going to change anything. So anything that would be regarded as something that's material should probably call for a revisit to and a review of the collaboration agreement.
Also, you've also discussed both industry and industry academic partnerships. Are there different considerations that one should consider if it's an industry academic partnership as opposed to an industry partnership?
What I've seen over time is that I think one of the big issues that comes up in industry academic partnerships or industry small company partnerships versus large company partnerships is the fact that universities, and sometimes small companies as well, small startups, but particularly universities, are involved with multiple partners, whereas big companies oftentimes are not as much in one field. So for example, you may have a university person, and the university researcher may be coming up with new oncology drugs. And the university may be granting field of use licenses to different parties without actually transferring the ownership of the patent. And one of the things I alluded to earlier is that as a result, because the university is the owner of the patent, if there is a litigation down the road, the university now has to be a party to the litigation, whether they like it or not. And so now let's say, for example, the university licensed a field of use license for one field of use to company A, and they licensed a field of use license to company B, maybe for a different technology on a different patent. So the university is partners with A and B in different areas. Well, now let's say company B did something which infringed the field of use license that was given to company A for the first area of technology. So company A, of course, is going to want to sue company B. And most research agreements have a provision requiring cooperation of the parties if there's a litigation, which means now the university is the patent owner. They have an obligation to cooperate with the litigation. Not only do they have to cooperate, but they have to be a named party because they're the patent owner. So now they are the plaintiff in the litigation. So legally, in fact, they are now suing Company B, who is also their partner in a different area, which the university may not want to do because they're partnered with B, but they have no choice. And as a result, they may be in a situation where they're forced to sue or forced to be in a litigation where they don't want to. Let's soften it. Let's say they're not involved as a partner with Company B, so they don't have that concern so much, but they're still required to be a party to the litigation. And what they may not be aware of or giving it much forethought, when they entered the agreement, the money came in for the research, and that was good. The technology maybe came in from the company, which helped promote the research and help the research progress, which was also good. But what they may have not given a lot of thought to is that now, 10 years down the road, 15 years down the road, now they're involved in a litigation, and whether they like it or not. And even if Company A is solely paying for the litigation, which typically is the way most agreements are drafted, that if you want to sue somebody on your own, you need to foot the bill for it. So Company A is paying for it. It's not going to necessarily cost the university anything in a direct out-of-pocket paying for the litigation. On the other hand, it's still very disruptive because the inventors who are at the university will inevitably get deposed during the litigation, which is very disruptive to them. The records at the university will probably be subject to discovery if there's communications between the inventor and other people, which are not protected because maybe it's just other people, not non-lawyer people, let's say, other people. Perhaps the researcher communicated information about the technology to somebody in another lab somewhere. All of those communications will be subject to discovery, and it'll require pouring through lots of documents and records, and it becomes incredibly disruptive to everybody involved. And a lot of times parties don't think about those long-term potential down the road ramifications when they're entering into agreements. And if you want the relationship, sometimes you can't avoid it. If a litigation happens, you have to deal with it, and there's just nothing you can do to avoid it. But you can sometimes mitigate how much you're impacted by it, by how the collaboration agreement is structured. One possibility is if the University Tech Transfer Office allows this, and oftentimes University Tech Transfer Offices do not allow this, but if it's permitted to actually transfer ownership to the partner with a license back to the university, maybe, or even with some kind of ongoing royalty payment to the university when the company uses the patent, but it's a full license as opposed to a field of use license, then the university is no longer an owner of the patent, and they are no longer a required party to the litigation. So it would mitigate the involvement and the impact on the university if there is a litigation down the road. May not exclude them completely, particularly, again, if the inventors are deposed, things like that, but it at least will mitigate it somewhat.
And can you contract? Are there ways in the agreement to allow for the equitable and practical methods or investigation of assigning ownership of the patent, or basically to identify who the inventor should be on a patent?
Absolutely. Anytime there is an invention, particularly in a collaborative research agreement, the inventorship should always be considered and investigated. Usually I would say by someone who is, by an attorney outside or an attorney in a tech transfer office if it's at a university, but ideally by an outside counsel, because oftentimes people may confuse authorship on a journal article with inventorship, and they're really two different things. and then to be an inventor, you really need to contribute to the conception of the invention. And it really helps to have to forego disputes later on by having the inventorship formally investigated and determined as to who the inventors are. If possible, it's even recommended to have everybody involved in the project draft up in their words what they perceive as their contribution to the invention. Then have the outside person consider what the people said their contribution is, talk to the people, come down with an inventorship determination, and have everybody sign off on the conclusion of the inventorship investigation. Because once that's done, it's much more difficult for someone to come back later and say, oh, I should have been named as an inventor on that patent, and I have rights to that patent, if there was a full inventorship investigation and that person signed off on the investigation determining that they were not an inventor. So it gives us a lot more credibility to the side saying, no, you're not an inventor, if the person, in fact, was involved in this investigation and at the time signed off on not being an inventor. So yes, I would highly recommend having inventorship investigations done.
And finally, last question. Somebody was asking about the poor Stanford researcher, and is there anything, basically it seemed that that researcher breached his agreement with Stanford. Is there any approach that that researcher probably could have done differently so they weren't serving two masters?
Well, I would say, and this comes up quite a bit at for some reason, I hate to say it, but it comes up more with universities, and people just sign stuff because they're so focused on getting the research done that they just sign off on things. So my recommendation is don't blindly sign things. Read them. Now, in this case, it wasn't the researcher's fault per se, because CETA said he had to sign it, Stanford said he had to sign it, and really he should have just kicked it back to both of them and said, look, you all need to figure out what you want me to do here. You both have, I can't sign two agreements. Now he had to sign the one, Stanford was his employer, excuse me. So he really had to sign that one. Now, one of the other factors that I didn't mention that also worked in CETA's favor is that the employee handbook for Stanford says that they tend to favor ownership in the inventors. So given the context of Stanford's policy of saying, oh, we like to favor ownership residing in the inventors, and the fact that they didn't have him sign an actual assignment, only in what was interpreted as a promise to assign, the court said that he assigned it all to CETAS, and there was enough wiggle room in the Stanford employee agreement that allowed him to do that. So I would say, don't just sign off on things. Read them, take them to the legal department, ask for the legal department to comment. One of the other big areas where I've seen researchers run into problems, not just at universities, but at small companies sometimes as well, is when they get a resource from ATCC, the American Tissue Type Culture, and they have ordered some kind of deposit, whether it's a cell line or a monoclonal or whatever they've ordered because they need to use it, not realizing it's actually a patented cell line. And with that, inserted in there is a sheet that you need to sign off on saying that you acknowledge that it is a patented cell line and you understand that somebody else has the rights in it. And then they send that back to ATCC, and ATCC notifies the patent owner that someone has purchased the patented cell line, and now the researcher gets a warning letter because they're using the patented cell line, because they signed this acknowledgement without really thinking about what they were signing. So yes, I would say the poor guy at Stanford was kind of caught in the middle, but should have gone to the legal department probably and asked for guidance.
Well, I think that's very good advice. And thank you for your time, MaryAnne. With that, I will turn it back to Mike.
Well, thank you, Krista and MaryAnne, for sharing your time with us today. The Chemistry and the Law Division focuses on educating others about the issues that arise at the intersection of chemistry and the law. So make sure to join us for the next broadcast on May 9th, which will focus on considerations that should be taken in license agreements. Also, remember that if your stenographer missed any part of this broadcast, its recording and all other recordings are housed at the ACS Chemistry and the Law Division's YouTube channel.